Hello, my beautiful friends. What an amazing day it is. Welcome back. I hope that your week has been absolutely outstanding and you are roaring and ready to go on this lovely and incredible Friday. We made it through another busy week, but we're not done yet. We got some serious business to attend to, and let's do a quick preview before we zoom on in for further detail. Here's what's coming up. Of course, Lisa Cook, the governor of the Federal Reserve, a governor, has now got a third property that is a problem. So, they say one is something, two something, and then three is you're in big trouble. And so 3 strikes, you're out is how this is going to go. We've got the documents queued up here. You can see I've got the referral from Bill Pulte that he sent over to this Pamela Bondi team along with Ed Martin. And so we'll go through that and then we'll go into the docket, okay? Because she is suing, saying, I'm not fraudulent. Just because I lied on my interest rate, my mortgages, doesn't mean that I can't be honest and full of integrity on the Federal Reserve. But of course, we know how the response will come. And so we've got a response today. So Trump, we went through her filing yesterday. Trump responded today, and Jerome Powell responded today, and they had a hearing today as well. All right. So Inner City Press was there, and he's going to be reporting on this for us. And so we'll get into that and see what the latest is from the hearing that just took place. It's taking place like right now. All right. So we'll come back to that. 49 minutes, 42 minutes. We'll see what happens. And we'll just let that puppy continue to cook. So we got some filings to go through. We've got some reaction to this. You'll notice that the Politico website changed their headline about the judge who is going to be handling the case. And we got some questions about this going on because Roger Stone says that they might have been in the same sorority together or something like that. So we'll talk about it. Then we'll turn our attention over to this 9/11 case, man. We got another anniversary of 9/11 coming up, and we still have a lot of questions about it now that we know how rotten our government is. They lie to us about Biden's mental faculties, Afghanistan, the sanctity of our border, about inflation, about the CDC, about January 6th. So why would they not just lie to us about 9/11 too, right to our faces without any even feeling bad about it? But now this decision came down from the Southern District of New York. It's 9/11 families versus the Saudis, basically. And the Saudis filed a motion to dismiss on this thing. They say there's no evidence at all that we had any involvement in 9/11 whatsoever. And of course, the dismissal of this means that that's not entirely accurate, right? Maybe there is actually a claim to be made. And so the case can move forward and the Saudis are not off the hook on this. And this is an interesting one because we were also yesterday talking about Ron Coleman's lawsuit against the UK, and we'll be able to do a little compare and contrast on this because they actually created some special laws for 9/11 that we'll see how that impacts the analysis. So some 9/11 stuff. We've got other people are asking about other weird things that have happened in America, like Thomas Matthew Crooks. Holly is saying we need to declassify the entire Butler file, which I couldn't agree with more. It's insane that basically nothing has happened after Butler. Nothing. 6 Secret Service agents, as far as we know, got suspended, but that's about it. And Tucker is going to be coming out with a 9/11 special. And so we'll play the little trailer on that. Looks good. I'm curious to see what he says about it. He's got some interesting imagery in there as well. And so we'll talk about that. And then another big story popping today is that Kamala has now been stripped of her Secret Service protection. And she wasn't entitled to it anyways, all right? She gets 6 months of it. Joe Biden issued some secret order and extended it just like he did everything. Hey, Stacey Abrams gets $2 billion. You get $2 billion. You get $2 billion. You get Secret Service. Nope, not anymore. So it's rescinded and she'll have to get her own security, but nobody even goes to her events anyway, so no one's going to care. So we got that. I got Jake Sullivan come out and he was asked point blank by this dude, Tim, about Joe Biden's mental capacity. And wait till you hear his answer. Obama is out. We've got Comer is out explaining that the Biden auto pen scandal is just heating up. And we're excited to get into it today, my friends. And so thanks for joining us today on this early stream. Membos, stick around after the show. We'll have an after party and say what's going on. And of course, Membos, we'll be back tomorrow on our Saturday stream. Can't wait to see you there. Thanks for supporting our show by subscribing to our channel. And if you'd like to, becoming a member, we really appreciate it. We have great streams. We have an awesome community, the best people, and we'd love to have you come join us. So you can click on watchingthewatchers.locals.com, join over there, or click the join button on YouTube, and we'll see you in the after party. All right, my friends, thank you for being here. I hope your Friday is off to an awesome start. Now, let's get into it and zoom in. I think the tubes are all working. It's pretty good. All right, let's do it. Lisa Cook busted again. 3 strikes, you're out, says Bill Pulte. And we're going to go through all of the updates on this case because President Trump has responded to her motion, which is to basically have her reinstated at the Federal Reserve. We covered that in a prior video, but this is Trump's response. And we also have Jerome Powell's response. And we also have a court proceeding that is taking place right now. And we'll go through exactly what happened. But the story starts off with this message from Bill Pulte, FHFA. He says, 3 strikes and you're out, Lisa. Today, the U.S. Federal Housing sent a second criminal referral in the matter of Lisa D. Cook. That's number 2. Related to a mortgage on a 3rd property and alleged misrepresentations about her properties to the United States government during her time as governor of the Federal Reserve. And that's what we were talking about yesterday, okay? She had to kind of continue the fraud in order to maintain her position and by not disclosing it. So that's an omission. And so she was giving misrepresentations. All your finances are in perfect order? Yeah, of course. Of course. I went to Harvard or Stanford or whatever, and I taught there. Only 8 months later, we got this. On April 7th, okay, so we got to keep the timeline clear, Cook entered a 15-year mortgage for a condominium in Cambridge, Massachusetts, representing it as her, quote, second home. And only 8 months later, on December 1st, 2021, she signed an ethics form with the U.S. government that this property was an investment and rental property, not a second home, in subsequent filings from 2022 all the way to 2025. So her disclosures were not even accurate. And Cook consistently listed this property as an investment and rental property and not a second home. But in subsequent filings, let's pick up here. Representing the property as a second home may have allowed Cook to secure a lower second home mortgage down payment and rates, as investment properties typically carry higher down payments and higher rates due to increased risk. Now, additionally, Cook allegedly misrepresented her Atlanta, Georgia property all the way from 2022 to 2025 to the U.S. government, again, as part of her disclosures. And by their own admissions, in her argument yesterday, she was, to summarize, she was saying for cause. The statute says the president can fire a governor for cause. That's it. Doesn't give us any details on what for cause is because it's up to the president. It's whatever he decides is the cause. That's what the law says. For cause by the president. Anyone else? Nope, just the president. Okay, great. Why? Separation of powers. Because you cannot have somebody who is at or above the president. Okay, so you got to be subordinate to somebody else if you're executing the law. That's the structure of our Constitution until these maniacs perverted it with the Federal Reserve Act, which created these pseudo-private entities that are illegal. Now, the second home mortgage, she says, is not for cause. And the for cause explanation, they wanted to narrow that down. Okay, the definition I just gave you was very broad. Whatever the president says is cause. That's what the law says. So he can decide. You might disagree with it, but it says for cause by the president. So she wanted to narrow that down. She went to find some old case law and she says it's only for like inefficiencies in office while you're in office or malfeasance in office or something, and narrowed it up. This is a violation of something in office, failing to disclose multiple years, multiple documents, right here, 2022 to 2025. So by her own acknowledgement, by her own rules, that's cause. Now, additionally, Cook misrepresented this, and she also similarly declared in a 2025 government filing that her Ann Arbor, Michigan property was her personal residence. However, we have reason to believe that as of 2025, the Ann Arbor property is being used as a rental property, not a personal residence. These inconsistencies appear Cook made additional multiple false representations, including to the U.S. government. Oh, regarding the status of her mortgages and the properties. Busted! 3 strikes, you're out. All right, here's the official referral going over to Pamela J. Bondi, courtesy of Bill Pulte at Housing, saying, all right, Pam, you know, as director of the FHFA, the Federal Housing and Finance Agency, I reiterate a referral. I already sent you one for this criminal, but we got another one. All right, now there's this concerning a third property, which appears to be multiple false representations made about those properties to the U.S. government while she was governor of the Federal Reserve. Uh-oh. They said it all happened before she got there. I committed all my fraud before you hired me. So it's your fault. Should have looked into me. Sorry. I got one past the post, and so now everyone has to suffer for it. And she can have fraudulent mortgages and just enjoy the fruits of her criminality. So while she was governor, by her own standard, she's busted. So on April 7th, 2021, and just 4 months before Cook took out 2 separate loans where she falsely declared 2 separate properties as her primary residences, Cook entered into a 15-year mortgage agreement at a condo located in Cambridge for 361 G's. She said, well, that's my second home. We just want to go up there in the summers. According to the mortgage agreement with the Bank Staff Fund Federal Credit Union, Cook told them that she was going to occupy and use the property as a second home. However, 8 months later, after telling the bank it was going to be her second home, she told the U.S. government that she earned $15,000 to $50,000 in rental income, and she declared it as an investment rental property, not a second home. Oh, so she puts on there, yeah, here's my disclosures, right? Ongoing disclosures every year, ethics, compliance, update it. Anything change? No. Any new investments that are conflicts? No. Your husband? No. You got to go through it. She put on there, it's an investment and rental property, which is probably accurate, right? Because it sounds like it is. That's the accurate one. The problem is she said it was a second home to the mortgage company. So there is a disagreement there. And she said that so that she could get a lower rate, lower down payment, and make more money. Now, here's another one under liabilities. Bank Fund Staff Federal Credit Union. She's got the loan mortgage here. And then again, in multiple filings with the U.S. government, again, from 2022, 2023, 24, and 25, she said investment rental property, not a second home. Now, second homes receive lower mortgage costs than investment properties because investment properties are riskier. Now, this is extremely troubling, says Bill, because in addition to other reasons, by potentially falsely representing the property as a second home, Cook may have received savings by not declaring it as an investment property. Right, save money. And Cook did all this while serving as governor of the Federal Reserve. Those disclosures are supposed to be accurate. Cook attempted and is currently renting her property in Atlanta, Georgia. However, during her time as governor and while under consideration for the Senate, Cook, in disclosure filings, said that that was a personal residence. Whoa. Yeah, that's dishonest. It is inconceivable the property could be both her personal residence and a rental and investment property, unless it's like subletted or something. Now, while serving as governor, she also misrepresented her Michigan status. Says similarly, her 15-year mortgage with the University of Michigan Credit Union requires her to use the property as her primary residence. And in her personal filings, she has consistently disclosed this as her personal residence mortgage. But then in 2025, she said, Ann Arbor is still my personal residence, but the FHFA has reason to believe that's a lie. Either it's currently being used as a rental property as well. So she's not even living there. Woo! Now, they say with some analysis here, William Pulte, writing financial disclosures to the U.S. government required for all Senate-confirmed appointees are vital when assessing the fitness, the character of the individuals. Now, while the previously referred misconduct by Ms. Cook does necessitate review to determine whether there's been a criminal violation, Pam, Housing believes that even further scrutiny is required, given the conflicting nature of her financial disclosures, and to determine whether Ms. Cook has potentially made further potential criminal violations, as well as material misrepresentations to the United States Senate and to the United States government in order to, among other things, to retain and acquire her position as governor. Now, the DOJ should review to determine whether a violation occurred, specifically wire fraud. Let's go. Mail fraud, bank fraud, false statements to a financial institution. How about all of them? Says, as always, we look forward to cooperating with the DOJ to support any actions the DOJ finds to be appropriate to help ensure that the protection of American home buyers and taxpayers are insulated from mortgage fraud and other financial misconduct. From Bill Pulte over to Pam, and it's 3 strikes, you're out. Now, this goes further because Pulte is also hearing this, saying CNBC is now reporting that Jerome Powell has continued to let Cook have access to her office and to her electronics despite being fired. And you say, uh-oh. So Trump has the lawful authority to do that. It's not, I would say it's absolutely clear, right? It's pretty clear, especially based on the precedent that we've gotten from the recent Supreme Court. The law, I think, is on our side on this one. And I think the trend is towards no more independent, amorphous bodies that just float around our body politic like cancerous cells. We don't want that anymore. And so if Jerome is siding with Lisa over the president, that's a bad decision. It's just a chain of command. And he's got an interest, obviously, but the Federal Reserve is not the executive branch. They know that. Everybody knows that. They try to be kind of another fourth branch, but they're not. And so he should default to siding with Trump. You just kind of freeze her out for a little bit, stay her, don't fire her. But if he's allowing her to continue to do her business, he's complicit in it. And that's a for-cause firing too. And so maybe we just fire him next. Maybe Trump just fires him, and this just goes all the way up to the Supreme Court, and let's just duke it all out right now. As we were speculating yesterday, we thought would happen. Now, we've got reactions. So first, Powell responded very short, since we're talking about him. He said this, very, very short. He says, basically, I don't want anything to do with this. Can you just decide this for me? Because I'm pathetic. He says, you know, the Board of Governors and the Federal Reserve System, we respectfully submit this response to the motion by Lisa, which we read yesterday, for a TRO to stop Trump from removing her. As the complaint and the motion make clear, the board is being sued to ensure that Cook can obtain complete relief if she's successful. That's the only reason. There's like really no conflict here. So she's just naming them. Noting that the board is sued only to the extent it has the ability to take action, right? Now, thus, while the board has authority to independently litigate under the Federal Reserve Act and will be in attendance at the hearing, it does not intend to offer arguments about Lisa's motion. At this time, the board merely expresses this. This is what the Federal Reserve is saying. It says this, our board, we express its interest in a prompt ruling by this court to remove the existing cloud of uncertainty and its intent to follow this court's orders. So that's about it from them. Now, Trump is responding to Lisa's filing. And if you missed it, we read through her filing yesterday. This is the response to that. Here is what we've got. President Trump and the U.S. government now respond to Lisa Cook's motion to shove herself back down everybody's throat as the governor. Here, the Trump DOJ says, the Federal Reserve Act empowers the President of the United States to appoint, by and with advice of the consent of the Senate, the members of the Board of Governors, U.S. Code. Those governors serve for fixed terms, unless sooner removed for cause by the President. See, that's in quotes right there, which is because that is the statutory text. That is the actual law. For cause by the President. The statute, thus, is very clear, expressly contemplates that even setting aside his Article 2 authority over principal officers, okay, the president runs the executive branch. So if you're going to be executing the law of Federal Reserve, we're going to just withhold that. We're going to say we've got Article 2 powers, which are even more powerful than this statutory power because it's constitutional. Saying we're just going to set that aside right now. We're going to beat you on that too. But first, we don't even need to go that far. The president retains broad discretion to remove the governor for cause. Now, that's exactly what the president did. You don't see the word cause defined in the statute. Congress could have done that if they wanted to. Well, cause means whatever that is. They just said that it's the president's cause. And it's because they can't substitute their judgment for the president's lest they become the president. So this is a logical way to write and structure the laws. So that is what the president did here. Following the nomination and the Senate confirmation, she began serving in 2022. And earlier this month, the director, Pulte, referred her for criminal prosecutions for 2 mortgage agreements. Now, in both agreements entered within just weeks of each other, which is also weird. Like these all, I think, were in the same year. I mean, very quickly. Boom, mortgage, boom, mortgage, boom, mortgage. And they didn't check with each other. They're like, did you apply for any other mortgages recently? Yeah, 2 months ago. Okay. What? Says Dr. Cook represented that she would occupy each property as her principal residence. Obviously can't be true. And so the president publicized this referral and made clear he viewed this deceptive and potentially criminal conduct as grounds for termination. That's his cause. Doesn't say what the cause has to be. Good enough for him. We use his judgment, not someone else's. Yet Dr. Cook offered no defense to the charges. Yeah, we didn't see it. Not in public, not in private. We read through the whole thing yesterday and I didn't see it anywhere. She said she could have easily said these unproven and false allegations. She didn't say that. She said these unproven allegations. Just say it's false. Accordingly, 5 days later, the president terminated Dr. Cook for cause from her service as governor. As explained, the American people must be able to have full confidence in the honesty of the members of the Federal Reserve. So Dr. Cook now says this court should override the president, right? This judge is more powerful than the president. And we'll come back to who got assigned this case in a second, but it's Judge Cobb. And we got questions about the relationship between Cobb and Cook. And so here she says she wants us to reinstate her, but you don't need to do that. It's a meritless request for multiple reasons. Here's why. To start with, Dr. Cook is highly unlikely to win. Removal for cause is a capacious standard and one Congress has vested into the discretion of the president by the law. It's written in the law. You can see it. Even if it were subject to any judicial review, and over a century of case law suggests it's not, that review would have to be highly deferential, lest it intrude into the president's constitutional authority over his principal officers, okay? If a judge can say, actually, president, you can't fire that person or hire this person or whatever, then they're the president. They're not given any constitutional duties to do those powers. So they better defer. Now, and under any standard, making facially contradictory statements in financial documents, whether a criminal burden of proof could be sustained or not, doesn't matter, is more than sufficient grounds for removing a senior financial regulator from office who can't even regulate her own finances. Dr. Cook's contrary claim rests instead on an artificially narrow interpretation of cause, which we talked about yesterday, that finds no support in the statutory text and that would prevent the president from removing Dr. Cook even if she were criminally convicted for fraud committed before taking office, right? So her standard is it has to be in office. Malfeasance in office, inefficiency in office, some other reason, but while in office. So she gets charged, she gets convicted of multiple felonies. Now she's a convicted mortgage fraudster, and the president still can't remove her for cause because her definition would prohibit that because she didn't do it in office. It's a ridiculous position. So Dr. Cook also presses a procedural objection. She says, I didn't have notice or an opportunity to respond, but no court has ever extended due process protections for employees to principal officers of the United States. What a ridiculous claim. But it came from Abby Lowell. Nor does the FRA purport to do so, the Federal Reserve Act. We don't have to give you whatever you're claiming you're entitled to. In any case, the president did give Dr. Cook notice when he published the referral on August 20th. and only acted to terminate her 5 days later after it was clear that no adequate response was forthcoming. He's like, you got notice? I posted it on Truth. Everybody got notice. You're not special, Lisa. You got notice. You're a federal person. So you got notice. You're gone. And don't act like this is a surprise, okay? Trump does this regularly. So then he fired her. He gave her 5 days to rectify the situation. She didn't oblige, and now she's gone. So incredibly, Dr. Cook, even now, hazards no explanation for her conduct. Yeah, exactly. I was waiting for clerical error. I was waiting for my assistant did it for me or something, or I was high on Ambien, and points to nothing she would say or prove in any hearing that would conceivably alter the president's determination. You just have to come out and say it's false. No. It's a total misunderstanding. It's not fraud. Here's why. I didn't do that. And, there's more to the story. Like, that's kind of what Tish did. Like, Tish and Abby, they're like, no, we have other documents that show she never said that. And you just kind of paper it up, right? Just paper the hell out of it. But she's just like, I don't want to talk about it. Don't ask me any questions. Oh, all right. Well, you kind of have to interface with the government. That's the point of these mandatory disclosures and things. If you would have disclosed what was actually going on with these properties and been forthcoming with your disclosures for multiple years, we wouldn't be in this predicament. Under these circumstances, there was no equitable basis for putting her back in. Turning to the balance of the equities, recent decisions from the Supreme Court leave no doubt that reinstatement injunctions are improper, and we've seen a pattern here. Indeed, since January 2025, those courts have stayed no fewer than 9 injunctions purporting to reinstate federal officers removed by the president, right? The Supreme Court says, no, he can fire them. He's the president. Instead of grappling with the orders, which, as the Supreme Court has recently reminded, are binding as to the application of the equitable factors, thank you, Judge Gorsuch, for saying that, Dr. Cook repeatedly cites instead the orders that were stayed, and she even cites a Supreme Court dissent, which is a weird thing, because they told us she's extremely smart, like all this pedigree, academic background, like taught everywhere, law review, all the things. How come she can't properly read her mortgage documents? It's very strange. 3 times now. So this recent precedent aside, Dr. Cook identifies no irreparable harm that requires overnight relief. The next board meeting is not even until September 16th. Meanwhile, the president has a strong interest in exercising his constitutional right of removal, and so you should deny Lisa. More background on the Federal Reserve. Established in 1913 by the Federal Reserve Act, which was a shameful time of American history. It consists of the Board of Governors, Federal Open Market Committee, 12 regional Federal Reserve banks that serve as financial institutions, and they are appointed by the president, and they can only be removed for cause. Cook came in 2022, and she was going to serve a full term, and she was nominated by Joe Biden. And I think this might be a good time to pause and go over and just share with you a couple updates that we have on watcherfiles.com. And if you go here, we got a full Oppo research report on Lisa Cook. And you can see there's some interesting things in here about her background. So if you kind of scroll all the way down here, this is on Lisa Cook. This is on watcherfiles.com. There's a section in here about her confirmation and allegations of mortgage fraud. You can see how massive these opposition reports are that we're creating. But there was a whole section here on reparations, apparently, right? So this person. She supports race-based reparations, and some of this academic background is criticized because of claims of plagiarism, right? City Journal posted about this story, and they said here that there's trouble at the Fed, right? This is an article back from April 2024. An investigation into the Federal Reserve governor and her academic record raises questions. So she's a plagiarist and a fraudster? Lisa Cook is one of the most powerful economists. She taught economics at Harvard in Michigan, served on the Obama administration's council. But despite her pedigree, questions have long persisted about her economic record. Her publication history is remarkably thin, and her published work largely focuses on race activism rather than on rigorous quantitative economics. Her nomination to the Fed required Kamala Harris to come in and cast a tie-breaking vote. And by contrast, her predecessor to the seat, Janet Yellen, now Treasury Secretary, back then when this article was written, was confirmed unanimously. So 2024. Yeah, so what you see is a lot of questions about who this lady is, and the so-called pedigree that they talk about seems like it might be fraudulent. So Trump continues in his response, and Biden nominated her, and you can kind of see why he nominated her. Earlier this month, the director, Bill Pulte, sent a criminal referral letter to the DOJ detailing instances of potential mortgage fraud by Dr. Cook. He identified 2 mortgage agreements that we know a lot about. Now, both of Trump and Pulte released the letters, and Cook did not respond to the letter once they posted it on the internet, or offer any defense of her contradictory misrepresentations. Instead, in a statement, she said, "I have no intention of being bullied to step down from my position because of some questions raised in a tweet." It's a reference to mortgage fraud. The tweet is a reference to mortgage fraud. It's and a criminal referral that is going over to the DOJ. It's not just a tweet. So probably should respond to it, because now you're getting fired. So 5 days later, after she did, I'm not going to be bullied, she says it was clear. No response ever came. She could have, "Mr. President, hey, Bill, let me have a meeting with you. Let me explain. Let me show you the documents." Nope. The president removed her from office for cause, and he explained that neither he nor the American people could have confidence in this woman, in her honesty as a financial regulator, given her deceitful and potentially criminal conduct in a financial matter. Now, at minimum, this conduct is gross negligence that undermines her trustworthiness as a financial regulator. It's like if you're a practicing lawyer and you can't file a motion or something. It's like you can't be a lawyer. What are you doing? Get out. This is ridiculous. Or you're unethical or something, right? Like you stole money from your clients. They'll just say, "No, you don't get to be a lawyer if you steal money from your clients." She's essentially stealing money from her clients. She is somebody who is in a position, has lower mortgage rates, keeps our interest rates high, and is benefiting from that system, thieving from us. And it's now caught. So they give us the legal standard very quickly, saying we're going to win the standard elements of injunctions, but here's the background now on the argument. Dr. Cook's lead argument, Lisa's, and the only substantive challenge that she mounts to her termination is she says there was no cause, but that's without merit. At bare minimum, she has not demonstrated a sufficiently strong likelihood of success for this remedy of shoving her back in her position. The president's judgment about what constitutes cause is not subject to judicial second guessing. Even if some limited judicial review were appropriate, it would be necessarily highly deferential. Otherwise, you're going to intrude on the executive branch. And under any standard, the apparent falsification of financial documents is enough to justify removing someone from a senior financial regulatory role, even if the misconduct arose in a personal context, even if it occurred before her official period, and even if it doesn't rise to the criminal level. It's the appearance of the impropriety. It's not the actual impropriety. That undermines your confidence. That's cause. Dr. Cook, contrary's reading is both textually and pragmatically indefensible, right? Logically, it doesn't work. If you adopt her standard, it breaks everything. And the law doesn't say anything close to what she's arguing. So at the outset, she simply assumes that federal courts are free to second guess the president's determination. That's what they all think, because they don't like the president, man. They want to have somebody else be the president. Now, precedent teaches otherwise. At least this hurdle further reduces her likelihood. Now, over a century ago, the Supreme Court held that when a statute permits removal for cause, that is a matter of discretion and is not reviewable. They set that back in 1901. If the causes are not defined by statute, then the person who has that power determines the cause. On that basis, the court refused to consider whether a commissioner had been properly removed for cause, because if they get to decide if the cause is good enough, they're the president. If the statute had prescribed permissible causes, The court said it might have been proper to consider whether a particular removal comported with those terms, but if there's not a specification in the statute, there is no room for review because the statute says what it says. It means what it says. Where the statute gives a power of removal for cause, quoting, without any specification of the causes, this power is often discretionary, yeah. And unless the statute otherwise provides other limitations, we can't analyze it. So here, of course, the Federal Reserve Act says only that the president may remove a governor for cause. There is no specification of causes that suffice. Nothing is defined. Even Dr. Cook, so-called doctor, concedes it. And the prior case law and the president's removal of Dr. Cook for cause is a matter of discretion, and the courts can't review it. And there's precedent. Now, more recent precedent also confirms this. In fact, in 1994, the Supreme Court said, where a statute commits decision-making to the discretion of the president, judicial review of the president's decision is not available. Otherwise, the judge would be the president. Presidential action may be reviewed for compliance with the Constitution, but mere claims that the president has acted in excess of his statutory authority by exercising his discretion are not cognizable unless Congress carves that out. Now here, Dr. Cook raises only an ordinary statutory claim. She says Trump didn't have cause, but they underestimate, she does, the president's power in this role. It means the president must make discretionary judgments, and he needs a reason. Of course, he surely needs a reason, but the sufficiency and adequacy of the reason is committed to his discretion. And as such, you can't review it. And Congress didn't say there were any other privileges here. Now, in any case, there's plenty of cause here. Okay, so her standards are wrong, but there's plenty of cause. Now, even assuming judicial review is available, like if you're going to say, well, what is the president's cause? Is it good cause? Can I pass judgment on the president's cause? If you're going to look at this case, Judge, they say, fine, let's just lay it out for you, Judge Cobb, who we'll learn about in a minute. Dr. Cook's claim is without merit. The grounds the president cited, which is evidence of deceitful and potentially criminal conduct, are plainly cause. Just start with the capacious standard at issue here. The law does not define cause. And to discern the word's ordinary meanings, you can look to the dictionary. And cause means reason, and cause is broad, and it has to be broad, right? The canon of constitutional avoidance also counsels in favor of giving cause a broad construction, because if you narrow it, then you're impinging on the president's Article 2 powers. As an overly restrictive interpretation would unconstitutionally interfere with the Article 2 authority. Should have just read it. Even assuming that the Constitution permits Congress to impose some restrictions on the president's removal power, given the historic role of the Federal Reserve, unique historic role, which I wouldn't concede, a question the court need not confront here, because the president's actions are consistent with the statute. In other words, he's not using his Article 2 powers, right? He's using his statutory right. And these restrictions cannot interfere with the executive power because the president has a duty to take care that the laws be faithfully executed, right? This is the tension we always talk about. Take care. And I feel like that's capitalized, but I might be wrong on that. A construction of cause that does not permit the president broad latitude to remove a principal officer who is suspected of serious misconduct would raise questions over Article 2. If the president can't fire somebody, are they the president? Applying those definitions, there is plainly cause. A federal agency, you might not like Bill Pulte, you might not think he's legitimate or fair or whatever, we like him and think he is, but you might not. Doesn't matter. It's another federal agency. He's duly appointed. It's the operation of the government. Your opinion of his decision to make the referral is irrelevant. He made the referral. It went to Trump. Trump is the president. He has cause. These are people in legitimate places of power. And so their decisions hold. So he referred, and it carries weight, over to the DOJ for potential criminal prosecution. She got different properties, 2 mortgage agreements within just a few weeks of one another in the summer of 2021, less than a year before starting her service as governor, which is also weird, right? It's like, was somebody dishing her a bunch of money and she was offloading these into properties before she got that position, right? Each of these two mortgage agreements included a covenant representing the borrower that she would occupy these places and make it her principal residence. But to state the obvious, it is difficult, if not impossible, to see how Dr. Cook could possibly have honestly represented that she intended to occupy and use both a property in Michigan and a condo in Atlanta as her principal residence. One can be principal, one can be second during the same time period. She didn't do that. One of these properties was intended, presumably, to be a secondary residence or an investment property. And if those contradictory representations were made knowingly, those could be federal felonies. And if they were made inadvertently, they still demonstrate lack of care or negligence with respect to important financial matters. She can't even properly classify her homes. Why should she have any power on the Federal Reserve? Either way, it is entirely reasonable to treat this as cause. Governors of the Federal Reserve exercise significant power over the nation's financial system, way too much. For someone in such a role, engaging in deceitful and potentially criminal conduct involving financial matters should be disqualifying. The president might have less confidence. A board member might cheat on his taxes or something, and thus cannot be deprived of the power to remove because they're the president. And even the perception of this type of impropriety is damaging to the public's confidence in the integrity of the system because she is getting better deals than all of us because she is a liar, apparently, allegedly. And even the perception of this type of impropriety is damaging to the public's confidence, of course. Now, Dr. Cook says the president did not unambiguously assert that she, quote, actually committed a crime. So the president can only remove you if he's like, I believe you committed a crime. That's it? What kind of ridiculousness is that? Indeed, the president properly did not purport to prejudge criminal liability. Depends on a bunch of things. Mens rea, and this is not a criminal proceeding. She's not been subjected to any criminal punishment here. The president doesn't need to prove criminal acts beyond a reasonable doubt to remove a principal officer, and it is too glib to compare this to jaywalking. The documents here suggest potentially felonious financial impropriety in the context of a senior official with oversight over the financial system. It's not credible to say these concerns are legally inadequate. Now, somewhat remarkably, Dr. Cook and her motion never even tries to grapple with the referral or the concerns on the merits, which we said exactly yesterday. Where are they? Can you just explain it a little bit? All she offers is that the allegations are unsubstantiated, which means that they can be substantiated. They just got to go find the evidence, which is what's happening now. It is not clear what she means by that. No one knows. And the referral letter included the mortgage agreements, which speak for themselves. So the contradictory statements are self-evident. It's right there. It's in paper. Dr. Cook does not try to claim that the contradictory representations were somehow truthful or maintain that she acted without scienter, like knowledge of the crime. As explained, even that would not matter in this context. Those might be defenses to criminal charges, but they don't restore trust in the Federal Reserve. It's a whole different thing. But Dr. Cook's refusal to even offer an explanation or a defense makes it all the more impossible to conclude that the cause standard is unsatisfied. She hasn't even given an explanation for why the cause is bad. She just says he doesn't have it. Well, how come? Why is it bad? Well, because the standard is wrong. Like the law is wrong. It should be much narrower. All right. And she then excludes herself from the exceptions for removal. And it's all extremely self-serving, as you can see, and it's not how the law works. So they say these arguments are entirely untenable. In contending that Trump lacked cause, she rests on interpretations of the cause that are not supported by even the statute or common sense. First, she says that cause means inefficiency, neglect of duty, or malfeasance in comparable misconduct. But she provides no textual basis for that reading. Like, where'd that come from? And the basic principles of statutory interpretation, how we interpret the rules, actually point in the opposite direction. Soon before Congress enacted the relevant provision, the Supreme Court considered the constitutionality of the INM standard. And Congress did not use that language that was in the this is the same argument we've seen before, saying If they wanted to have for cause explained in the statute, Congress could have put it in there. They put it in other things, right? Like with the FTC. That was invalidated. Instead, it specified that the Federal Reserve hold office for less time, and so adopting her construction of for cause would ignore Congress's choice to include the standard. Like they could have put the language in there if they wanted it, they didn't. And second, she's also wrong to suggest that this occurred as a private citizen. Those are artificial limitations that have no basis in any text. No language in the Federal Reserve Act limits cause to anything occurring in the course of employment. She just made it up. Nor has Cook cited a single case that supports this clause. This failure is unsurprising, as Dr. Cook's interpretation would insulate all manner of gross wrongdoing. On her theory, the president could not remove a governor who revealed that they committed massive financial fraud as long as it happened before the confirmation. That cannot possibly be right. That rule's ridiculous. And third, she's going to fail again. Her suggestion that misconduct does not count as cause in the absence of a criminal conviction is also baseless. Beyond a reasonable doubt is for depriving someone of life or liberty. It's not the same standard for getting fired from a federal position. Here too, they'd like it to be though. Here too, they want that for the illegal aliens. They probably want it for illegal governors. Here too, the canon of constitutional avoidance counsels against her artificial limits because you would impede on the president's Article 2 authorities. And finally, she argues the president removed her from office based on a policy disagreement. In other words, Trump's trying to go and take out Powell. Now, insofar as she seeks a ruling, this court should decline to probe the president's judgment. She offers nothing but speculation to say that Trump is insincere in this, and that is no basis to set aside a presidential action. And Dr. Cook, she's not going to win on any of her procedural challenges either. She says that there's due process entitlements, and she said that they say this is crazy. The court must look what is being deprived. Here, she's saying that she doesn't have an opportunity to be heard, and she has no property interest in her public notice. We're not depriving her of life or liberty or property. So it's not the same standard. She's not owed those things. As a principal officer, she has no property interest in her office. Supreme Court held a long time ago. Public office is not property. It's not yours forever, okay? The nature of the relation of a public officer is inconsistent with a contract right. Similarly, the Supreme Court had little difficulty in saying an officer appointed for a definite time or good behavior did not have a vested interest or a contract right in his office. And they've tried to pervert this. You hear this a lot. Like, you fired these civil servants who've been here for 20 years. And they think they should be there forever, which I completely disagree with. I think it should be a rotational type of situation. But the Supreme Court decision remains binding on the question of whether a federal officer has a constitutionally protected. The answer is no. Okay, she has no due process claim. That disposes of that right there. And the cases she cites are terrible. She can't offer any procedural protections from the Federal Reserve Act. And by the way, she was given plenty of time. She got fair warning that the president viewed this as grounds for termination. He posted about it. And she even knows. She saw it. The referral, in turn, sets out the facts in detail. She never even explains what she more wants to know. And she didn't and hasn't offered any elaboration on this. Here, the objective was satisfied. Trump gave her notice. She simply declined the chance to offer a competing account of facts. Could have. Instead, she declared only that she's not going to be bullied. And even now, it's not clear what a hearing would accomplish because she continues to offer no meaningful response. She filed an 86-paragraph federal complaint we read yesterday and a 23 memo, yet she has not chosen to dispute any of the facts. All she offers is the conclusory claim that the accusations are, quote, unsubstantiated, even though the mortgage documents themselves are facially contradictory. The purpose of notice and hearing is to provide an opportunity to clear her name. And for a hearing that's mandated by due process, you got to have a useful purpose in addition to the other arguments. Trump's letter was very specific, and she has no facts, even in dispute, demonstrating that Trump's assessment was wrong. She's had multiple opportunities to make that claim and never has. Insofar as Dr. Cook hints, but never says, here you go, that the contradictory representations resulted from a mere clerical error. And so she must have put that in the TRO. We didn't read that yesterday. We read the complaint. So she must have said some sort of a clerical error there yesterday rather than intentional wrongdoing. That makes no difference. The president made clear that even if the representations were not criminally wrongful, they at a minimum reflect a lack of due care in financial matters that is incompatible with the role of a governor, right? So even if it's like a mistake, then it's negligence. Why are you making mistakes on very important financial documents? You're the Federal Reserve Board of Governor. So she's now saying it's a clerical error, which is, did you make the clerical error? Now, who made the clerical error? Was it you, Lisa? How come you made that error? Why did you do that? You just signed it wrong? You filled it out wrong? Is that all it was? You just, okay. Well, then that means you're not very competent when it comes to very important financial documents. So that's for cause, so get out. Even if it was an honest mistake or whatever, but it wasn't. She did 3 of these back to back. The Federal Reserve, three different properties. So come on. So the Federal Reserve has a special historical status, they say, which is ridiculous. And even if her actions were negligent rather than fraudulent, it's still cause. No further process would conceivably have mattered. And so all the balance of the equities weigh in our favor. The Supreme Court has recently recognized the government faces an even greater risk of harm if fired people are shoved back in. And ignoring the Supreme Court's orders in these other cases, right? Trump, the Wilcox, Boyle cases, where the firings were validated, says even setting aside those rules, she identifies no irreparable harm absent a TRO. And she says that irreparable harm is the deprivation of her job. But there's no statutory right to a function, right? You don't have that. That's not irreparable injury. Dellinger, that was the other person who got fired. That didn't break any new ground. Cases saying here, courts have repeatedly held that deprivation of a unique or high-level position is not irreparable. Okay, this argument was made many times. But she cites just one district court case, which is inopposite, and it was vacated as moot. And so her case law is also terrible. Now, she argues that she faces irreparable harm to her efforts as the governor. She suggests the president's actions are undermining the public's perceptions of the Federal Reserve as independent. But despite its independence, they're subject to removal from cause. And in any event, this argument is patently insufficient to show irreparable harm. So Trump is harming the Federal Reserve now. In the end, the balance of the equities favors the president, and for the reasons stated above, the court should deny Lisa's motion. Signed by Christopher Hall, Civil Division, over in Washington, D.C. Shout out to Christopher Hall and the team over there. Very nice filing, and it shredded her filing with good appropriateness. And so apparently I wanted to clarify the clerical error. It sounds like in another filing, and let's just see if we can dig that up real quick so we can clear that up a little bit. But here, let's just go to the docket, and we'll put this in here, see what the docket has for us. And so it must have been in her, we don't have a ruling on this yet either. We got a bunch of notices of appearances that have come in. Something was entered in error. Summons, motion for a TRO. Yeah, it's probably in here. Let's see if it's in here. Clerical. Yeah, there you go. And the president and director Pulte would not even have alleged explicitly that she benefited from any clerical error, or that such an error was intentional. Even if Governor Cook had committed the infractions as the president alleges, which she did not, the president would still lack cause. So that's kind of how it came up. That's her rejection. And the president and director Pulte have not even allegedly that she benefited from a clerical error. Like, did they just shove that in there? As a little clerical error. It's in there one time. And yeah, so that's what we got on that. Let's see if there's any explanation of that in the actual motion, and do a little clerical on this. It's not in this one. No clerical error on this one. All right, so that's what we get. That's their explanation. It might be clerical. It's not even saying that it was a clerical error. It's just like, well, they haven't even alleged that she benefited from this clerical error. So they're calling it a clerical error, but who made the clerical error and why? Was it actually a clerical error or not? And if Lisa made that, how come she was so incompetent as to make that error on a pretty important document? So that is the docket. Now, we also have a court hearing, which is happening right now. And this case has been assigned to Judge Cobb. And so let's explain who that person is. And we created a file for her over at watcherfiles.com too. Should be right here on the homepage. Judge Gia M. Cobb is this woman right here. And she's got a lot of background. She was appointed by Biden in 2021. And she's got some interesting background. Indigent defense, civil rights lawyers. She was very aggressive with the J6ers. Biden nominated her. And at the hearing, it was a party line vote, 52-45, right down the line. Starkly partisan, despite her well-qualified ABA rating, ABA is a joke. The near unanimous opposition from the Republican Party demonstrated that there were serious points of contention here, right? The usual suspects, Susan Collins, Lindsey Graham, Lisa Murkowski of Alaska, they went and supported her. Thank you, guys. This narrow margin underscored the intense political battle, and she's been involved in a bunch of cases. Okay, so in some J6 cases, you see she was on the Stephen Chase Randolph case and these other cases, 4.5 years, 3 years, 18 months, 1 year probation, 2 years prison for seditious conspiracy. Gosh. And there were a lot of significant prison terms for people who didn't deserve them. Now we've got this Cook case. She's also been involved in the FBI case. So remember when the FBI agents sued, and I think Norma Eisen was one of those. She was involved in that case and she dismissed the case, but she validated the agent's fears, right? So she had to dismiss it, but you guys are right. She also was halting expedited removal in another matter. And it sounds like she's pretty liberal. Allegations of bias tells us that her background is involved in judicial activism. Yeah, has been really the criticism. And so a lot more detail if you want to read about her, those at watcherfiles.com from one of our deep research reports over there. But that's who is hearing the case right now. Now, in the matter of Lisa Cook versus Trump, Inner City Press is reporting and explaining exactly what's going on here today, saying Inner City Press is here and the judge is finally on the bench. Judge Cobb comes out. Good morning, everybody. Happy Friday. Glad you're here. Whatever. All right. I want to start with the government today. She says, is it your position that Governor Cook is like an employee with a property interest in the position, unlike an elected official? Because this is a unique position. It's not a government employee. So are you suggesting, says the judge, just notice and an opportunity to rebut before a decision is made? As a minimum? A says, let's say the allegations against Governor Cook is made by Pulte. It's before that person, we should have a chance to be heard, not in the Oval Office. Okay, so her lawyers are saying, we want notice before it goes public, essentially. Okay, well, let's talk about irreparable harm. Is she harmed? There are cases saying that not continuing in such a position, okay, losing your job, is not irreparable harm, okay? Because everybody would claim that. This is irreparable. I have to have my job. It's irreparable harm. Everybody would claim that. You have to go get another job. That's just how it works. The Federal Reserve is unique, they say. This person took an oath to operate independently, and you were taking away from me the right to do my job, says Lisa's lawyers. Well, there are cases, though, saying that the inability to carry out your statutory functions is not irreparable harm. But you are saying that this body, right, the Federal Reserve, is different? Is that what you're saying, says this judge? She says, well, Governor Cook and her brothers, this is Abby Lowell probably talking, that's the A, and sisters have only for-cause removal, and we believe that it is reparable. So her brothers and sisters on there, what a weird phrase. Her colleagues on the board? Judge says, all right, Abby, so you were saying that if the president replaces her, it is irreparable. Is that the question? So, well, the president, says Abby, just said a few days ago that he will have a majority on the board. And so the Senate has not exactly been doing advice and consent, Judge. And so this is irreparable since Trump's been doing all this. Well, is there any authority that you can put in your reply? Because we just read the response from Trump. Can you reply to him where the interim relief was reinstatement? Like, so while all this was pending, you want me to put her back while this is pending? Can you show me where that is? He says, yeah, That was Judge Ali. I'll look and put it in our supplement. Yeah, Judge Ali, Amir Ali, who was born in Canada like 2 years ago and became a judge like 2 years ago, whatever it was. Now acting as president, taking over control of the executive branch with his injunctions, and he's getting told too in the USAID case. But okay, now in Judge Cobb, is there any authority? He says, yeah, I'll look into it. If I were to grant preliminary relief, well, what's the remedy? Like, you've named the chair, Jerome Powell. So like, if we're in the middle of all this, what do you want me to do? Lisa's lawyer says, if President Trump said Cook is fired, but no one acted on it, I wouldn't have to be here. So we named Chairman Powell. So did Powell do something? So I'm thinking of the DC Circuit's decision in the Dellinger case. They said when Dellinger, we covered that extensively. Dellinger, I think, was the Hunter Biden friend. And he got fired. He sued. You can't fire me from the OIG, whatever. And they said, yeah, you can. Get out. They said it was not irreparable harm. He said, I'm entitled to my position forever, no matter what. Cook's lawyer says, well, what is she being deprived of, Judge? It's much more than just a paycheck. She is committed to the independence of the Federal Reserve. And so it's her commitment that's being irreparably harmed. If we've gotten there, we need to tell everyone that the status quo stays the same. Keep her electronics on. And let her, have her emails and continue doing her work so she can continue to, I don't know, whatever she's doing. Cook's lawyer says, I was struck by the government's brief. They want to apply the president's power to the Federal Reserve. The signers said something different in the Harris case. Judge says, all right, I've had enough of you, Abby Lowell. Why don't we see now what this government has to say? Writing from Judge Cobb. You agree that a difference to the government now, to the DOJ. You agree that a difference in policy view is not cause, right? Like if she wants the interest rates low and Trump are high and Trump wants them low, that's not cause, right? So anything that relates to a person's views is off limits. Is that right? Well, I wouldn't go that far. Someone might engage in abuse. Well, what do they say? Given what they say about the Fed being unique, like what is off limits, what's on, like if the Fed, like how does it apply to the Federal Reserve? DOJ says, well, that's why the president in the removal letter said you are being removed for cause. Okay, you're not just being removed. You're being removed for cause. The case law says that cause is discretionary and it's not reviewable, Judge. So I don't have to explain myself to you, nor does President Trump. So any reason at all, if it calls into question the ability to serve, well, what is reviewable by me, says the judge, in this context? Well, a person could say, I'm entitled to cause. You didn't give cause. But if you have a cause, the only question is whether it's just a policy disagreement. And is that reviewable? If it's a policy disagreement? He says, well, we're not sure under Reagan if you could review that question. Okay, so like if it's policy versus cause, can you make that decision? I don't know, he says, the DOJ. Judge says, well, I'm uncomfortable if a person says, I want a majority on this board, and then comes up with reasons. Like what happens if the president comes down? He's just like, well, that's cause. Jaywalking cause. Oh, you didn't tip your waiter. That's cause. Oh. And DOJ lawyer says, well, how are you going to tell? The courts don't do that, right? You don't get to go in and like, that's not your job. Okay. If the executive is doing things poorly, the check is you don't get to undermine their decisions that they have constitutional power to make by Congress, by the law. Congress can impeach the president, right? It's another branch of government that can check the presidential power and impeach him. Now, how are you going to tell? The courts don't do this. Until this referral came up, I'm not aware of any statement by Trump on Dr. Cook, so he's never talked about her at all. It's about the mortgage. That's why. Now, they have been very careful in their brief not to say what actually happened, other than that little clerical word, with this contradictory representation of two primary residents at the same time. Well, what if the reason for removal is just a pretext? He says, well, that's not the case here. It's not a pretext. She's got mortgage fraud. It's right there. Well, it's not here. Here, there's a senior regulator. She made contradictory statements about her residences, And a week later, after we found it, no explanation from her. Well, you say that she didn't respond to the social media post in 5 days, so the president acted. Does that 5 days satisfy due process? Yes. Well, how did she know she had 5 days? Well, she didn't respond in any way. No communication to the president at all. Well, what would the procedure look like? Like, what is the process? Doesn't a person have to be given information? No, this isn't a civil service lawsuit. We're not suing her. She's fired. DOJ lawyer says, well, she didn't say, that's not my signature. I think if there was something like that, we would have heard it. My assistant did that. Okay. I had assistance in the creation of the mortgage company, did that. I never signed it. I never signed that. If there was something like that, we would have heard it. So what would it mean to say the president should hear her out? I haven't heard what the story is that she would want to share. She could have shared it a long time ago. So what if something, though, the judge says, what if it's something the president knew and the Senate knew? If so, it feels weird that an administration could go back and second guess the Senate. Does it feel weird to you, Judge? Yeah. Well, that's not the case here, Judge. Cause bears on an individual's ability and fitness to do the job. Well, what would we do? Would we depose the White House officials who vetted her? No, that's a hard no. You don't get to do that. Judge says, well, this board is unique. Yeah. Why? It was passed by a statute like all of the other crap illegal boards. It's not an amendment. It's a statutory body, just like the rest of them. It's no different. Structurally, constitutionally, different functions, obviously, but it's a branch under the executive. It's not a branch. It's an entity under the executive, and it has been played to be like it's not. And our Constitution never was amended to make that happen. If they want to do that, then they can, but they haven't done it. So cause bears on an individual's ability and fitness to do the job. This board is unique. I understand why elected officials don't have a property interest, but this is closer to an employee. Well, the harm of having someone, and if it's an employee, if she's an employee, then she can go file her claims in the Merit Service Protection Board, right? DOJ lawyer says the harm of having someone in office that is wrongfully there outweighs the harm of losing the position. She says, oh gosh. All right, let me go back to due process, says the judge. There are cases that seem to equate as having a for cause requirement with a property interest. And shout out to Inner City Press, Matthew Russell Lee. You got an update from another case he's covering. Sweet. Says here, DOJ lawyer. Well, the remedy here would be tricky. Like, what are you going to do? What would a hearing accomplish if we have a hearing? Well, I don't know if they're saying that a hearing is required. Well, hey, send a letter. Just send a letter to the president. Maybe the president would change his mind, but you guys haven't done anything. You're fired. Now you're suing. Talk to him. Well, deferential doesn't mean there is no probing of it or no review, right? So I can look at these decisions. What does that look like? Says, well, when the president is statutorily empowered to make a determination and he makes it, that's it. That's the story. Congress said for cause. He decides that. Maybe in some extreme cases, but not here. Judge says, all right, plaintiff, Abby, you guys, what do you guys say? Your Honor, it's not different if the president just puts in the word because next to Article 2 doesn't make it better. The president said what he meant on August 26. He says if she acted properly, well, then he talked about interest rates. And could the president remove her for wearing a pantsuit? Maybe he should be able to. For teaching in a DEI college, is that cause? I use the word pretext cautiously. They say he said things about Chairman Powell, not Governor Cook. He swung at the person at the plate. Yeah, and apparently she believes in reparations and all sorts of things. So if she believes in reparations, how is that impacting her economic policy? And is that in alignment with good economic policy for America, according to the duly elected American president? Maybe not. He swung at the person at the plate. Cook's lawyer says it was Pulte. Bill, he posted on social media about 2 different entries, and I don't accept his representation that they're contradictory, at least not here. This is about the TRO, and as I said when I rose to the podium the first time, I avoid social media. It's too bad. I wish Abby would watch our show. Cook's lawyer says the president gave her 30 minutes. 30 minutes, Abby. That's all. After the tweet, the president said if she doesn't resign, not answer or explain, but resign, then I'll fire her. And that's not due process. And there is the question, where should that take place, on the internet or not? Was she supposed to respond to him publicly on social media? That's not due process. I can assure you the Senate reviewed bank records. They had an opportunity to look. A new president should not undo this. And says Dellinger, the other guy who got fired, was allowed to remain in office during the review until he was not. Here they said she had 5 days to respond to a tweet. That's enough, but that's not the case. We are in a unique position with the Fed. They acknowledge that in the NLRB and the other cases, but they didn't validate the argument that they're also independent. They just said they're different than these other agencies. So don't take, when you're arguing about the NLRB, you don't get to bring in the Federal Reserve to support your argument because you're different than them. But that's not judgment on the Federal Reserve and their validity. So the DOJ lawyer responds and says, Your Honor, just to say, counsel focuses on the August 26th statement. I think it was on YouTube. I understood that President Trump was saying that if the press had done its job, we wouldn't have Lisa Cook on the Fed. It was not an acknowledgement of any pretext in any way. Just saying, if somebody would have found this out earlier, she wouldn't be here as a fraudulent person. DOJ lawyer explains, Dellinger was temporarily allowed to stay until the DC Circuit overturned that. And they were wrong. Like, letting him stay was wrong. Judge says, shoot, I know. On scheduling, you're going to file a reply on Tuesday. Should I ask you to confer? Is this now preliminary injunction or should it be summary judgment? Or what do we want? Lisa's lawyer says, well, their position seems to be, let this play out for the next 3 to 7 days. And meanwhile, the president appoints someone else. Judge says, I'll need time to review this. I'll give you an opportunity to supplement this. Try to do it on Tuesday. Man, and shout out to Inner City Press, Matthew Russell Lee reporting. Going to repost this at the top of our timeline so you can give him a follow. And we appreciate him taking us inside the courtroom. Now, more reaction to this. Here, Pulte said, Lisa needs to step aside. With the evidence coming out on her third mortgage and her alleged misrepresentations, I believe she is causing irreparable harm to our beloved Federal Reserve. How is Jay Powell fine with her behavior and letting her stay here? Hans also said, let's take this up, baby. Let's fire Jerome right now for cause. And the Supreme Court can just settle the whole thing for us, which we love that idea. This was also an interesting one from Mike Davis talking about the judge. He said, how come Politico changed their headline? Okay, this is new headline right here. Meet the judge who will hear the lawsuit over Trump's federal firing. We met her. That's the new headline. Old headline is the judge who will weigh Trump's move against the Fed has tangled. The judge will have to weigh a lot in this case, no doubt. It's going to be a heavy load for her, as we saw in the transcripts. All right, so that's shout out to Mike Davis. We appreciate that one. And Roger Stone is also bringing this up, saying Judge Gia Cobb was Lisa Cook's sorority sister. Are you kidding me? I don't know if that's true or not, but I mean, that's a wild thing to say, right? Cook and Cobb were in the same sorority? Wow. So we'll keep our eye on that update, but ultimately Jerome Powell is basically in this predicament right here, courtesy of Zero Hedge. Which one you going to pick, Jerome? She's a moron or she's a criminal? You got two options there, Jerome. So you just got to press a button, my man, and make a decision. Now, this guy, James Fishback, is doing an awesome job, and he was over on with Fox Business, and he's filing amicus briefs, and he's somebody who's in the financial sector, and he's saying, this is ridiculous. Like, financially, he's the CEO of Invest Astoria. I'd encourage you to follow him. He posts great stuff and is doing good work on this case, and a lot of cases, but J_Fishback on X, and he was on with Fox. He says, Lisa Cook took out 2 mortgages, and that was a big fat lie. Here is what he said over on Fox. Let's turn this audio on. Why is this? Let's see what's going on with this audio. Okay. Do we have, let's check a setting over here. See if we have a little setting change, sound settings. See where this is going. Huh. Is it just this video? All right, let me try another video and see if this will play. Nope, not here either. All right, checking out, testing.
Politics, I will point out that
All right, my apologies for the technical difficulties. I don't know why I'm not getting audio today. And now this is not playing, so let's go back over here and see if this will play. Not working. Is the whole system just crashing down right now? What the heck's going on over here? Are we connected to the internet? Golly. All right, so hopefully we are. I don't know why none of our videos are playing right now. The heck is going on right now? Are we streaming right now? Hopefully we're live. All right, so I had a couple of clips for us. And my technology is not working at all, and I have no idea why. All right, well, that's okay. So we'll continue on and jump into the next segment as soon as this fixes. All right, so that's the update on Lisa Cook. We're going to keep our eye on this case. Thanks for subscribing and joining as we do. All right, I don't know what's going on with the sound, so let's just carry on and hit our next segment. And hopefully we're still coming in loud and clear. Let me check the tubes. Yeah, we're streaming, right? We're still live. That's good. I don't know why the sound's not working. Let's see. All right, well, we'll figure it out. All right, so let's just continue on, my friends. We got a couple of other updates here, and so let's hit this one. Victory in a 9/11 case still going on, and we're coming up on another anniversary here. And we're asking questions about 9/11. We know our government lies to us about basically everything. Lied to us about COVID, lied to us about immigration, about Biden's mental faculties, about Kamala's mental faculties, lots of things. And it seemingly appears that there are still unanswered questions about 9/11. And one family and group of people have sued the Saudis on this. The defendant here is the Kingdom of Saudi Arabia, defendant Kingdom of Saudi Arabia. And they filed a motion to dismiss this case, and it has been denied. And so here's some background on this. They say the Kingdom of Saudi Arabia moved to dismiss all claims filed against it in 2004 and filed numerous motions since then. They argued, we're immune. You can't sue us. On September 29th, this court granted the motion to dismiss because they failed to establish a tort. Now, on remand, this court concluded that another allegation of their direct liability, saying that the Kingdom of Saudi Arabia was directly responsible for this, were insufficient to establish jurisdiction. But they did explain that the nature and the scope of the agency is somewhat unclear in this case, and the party in the best position to shed light on that inquiry is Saudi Arabia. Now, the discovery was aimed at examining whether and to what extent these agents took actions at the behest of Saudi officials to provide assistance to 9/11 hijackers Nawaf al-Hazmi and Khalid al-Midar. So, did these Saudi officials help the hijackers? And if so, who were they and what did they do? Magistrate judge supervised this discovery to see whether, well, what did those agencies do? Maybe we do have jurisdiction. After its completion, the judge set forth a protocol for the motions to dismiss briefing. They renewed their motion to dismiss and moved to strike the opposition. Both parties brought motions with 7 expert witnesses, and it's been a battle. Now, we fast forward through some of the legal standards, and let's see what's going on in this case. Now, there are evidentiary objections, and yeah, this is interesting. So it's a detailed lawsuit, but they sent these two guys into the U.S., right? The Saudis. Back in 1994, he was employed as a civil servant. He remained there. They sent him into the United States. This guy also came into the United States, Bayoumi. From 94 to 2002, various education programs. This person, 96 to 2003, held diplomatic status visa. Usman Mada, an employee at King Fahd Mosque, declares that they were hostile toward America and Western culture. And they led a small group of men at a mosque who had extremist anti-American views. It's really nice we let them all in here. Says, then hijackers arrived in LA. So the Saudis have these two dudes here. Then the hijackers come in. Nawaf al-Hazmi and Khalid al-Midar were two al-Qaeda members who helped carry out 9/11. In 2000, al-Qaeda sent hijackers in the U.S. to study English and take flight lessons. We're like, yeah, we love foreign exchange students here. Great. According to FBI interrogations of KSM, who was an al-Qaeda member, these two hijackers did not speak much English before they came here and we taught them it so they could blow us up. KSM states that al-Qaeda had one in California to help the two, and he permitted them to go to the local mosque to request assistance. So then they arrived and they met with this dude. On January 15th, the two hijackers met with Thumiari. Muhammad Johar, a congregant, testifies he met the hijackers in front of the mosque after they arrived. He brought them into the mosque and introduced them to other people. He states that he told them that these two men were newcomers and needed to find a place to stay. Yeah, come to our terror cell. That'll be great. According to the FBI's interview, he stated that they told him to look after these two very significant people. Now, there are other Saudi officials. Now, while the parties dispute the political reasons behind the MOIA and their creation, it's undisputed it was created in 1993, and it assumed control over mosques. It vetted sermons and other things. According to the FBI, though, they had provided funding to a terrorist group, and Thumiari controlled the bank account that distributed those funds. Now, Khalid al-Swalam was the head of the Dawah office, lots of, names here, and other head of an affair. This guy left the U.S. for Saudi Arabia shortly before the 9/11 attacks. 5 weeks after the 9/11 attacks, some CIA and FBI agents came to the King Fahd Mosque with a picture of Thumiari and the hijackers. They asked the director of the mosque questions about him. He states he was never aware of this happening. No idea. KSA's Ministry of Foreign Affairs instructed him not to return to the U.S. without further notice. And the king approved his return to the U.S. back in November 28, 2001. And he did return, but the U.S. State Department ultimately revoked his visa finally. So then this other person, Bayoumi, made a trip over to San Diego, and he met the hijackers there too. He stated the purpose of his trip was to renew his and his family's passports. These people converted. During the trip, they met at a mosque. On February 1st at the consulate, they met with someone else. Morgan also declares that they met here. Hijackers met in LA. So it's a lot of background on all the meetings. Then here's another meeting. The hijackers' time in San Diego. They're at the mosque there. They got assistance with an apartment. Social gathering at the hijackers' apartment. Instructed Morgan to videotape part of the event. All male guests, it's a sausage party over there, because Islamic tradition requires families and unmarried men to be separated. Says that the party was an occasion to honor volunteers at the mosque. Now, as seen from the video, there were 29 people there. It's a lot of dudes. Some of the participants at this meeting had interactions with the hijackers outside this gathering, and the hijackers ultimately left. So Bayoumi traveled to Saudi Arabia. From March, his compensation more than doubled. According to personnel status changes, he explained this increase was for the more work he was doing. Then, while he was in Saudi Arabia, a phone call was placed from a phone number associated with his wife to a number that we claim, the families claim, to belong to this guy, Alaki. And there was a phone call between Thumiari and a number associated with Alaki. And Thumiari testifies that he never heard of Alaki and doesn't remember calling him at all. So this guy's in Saudi Arabia talking to these people. The hijackers' lease at their apartment ends. They develop a relationship with Hazmi. Hazmi and Mitter called Johar. The hijackers stayed at a motel. During this time, they visited the Saudi embassy and flew to Saudi Arabia. They also were in and out of Yemen and San Diego, Lemon Grove, California. There's a traffic ticket showing that Bayoumi was pulled over by the police at a location miles away from LA, from the mosque. Then they make a video in Washington, D.C. They take a trip out there. Then there's an airplane drawing. The MPS also sees the notepad from his residence in the UK. On one page on the notepad is a handwritten sketch of an airplane with some numbers, calculations, and some notes. Now, Bayoumi states that it is his own handwriting on this page. And regarding the purpose of preparing the document, Bayoumi states that he prepared the document to memorize the equation. So all of that, man, lots of facts. In summary, motion is denied. Parties present dueling narratives on whether and to what extent these agents took actions in 2000 at the direction of Saudis to provide assistance to the hijackers. Okay, it's a dueling narrative. Now, the plaintiffs, they present sufficient facts to support a reasonable inference that their claims satisfy this jurisdictional exception, and KSA does not convince this court that the exception does not apply, and so therefore, this court denies the motion to dismiss, and saying they still have jurisdiction over this case, in other words. Saying, now we have to talk about the scope of employment. Can we attribute this to the Saudis? Now, the plaintiffs say that the Saudi government charged these people, Thumieri and Bayoumi, to carry out covert activities to help the 9/11 hijackers. They say they've satisfied the exception. That gives us jurisdiction over them because there's 9/11 laws that said you can go, make claims. KSA argues that no one from the Saudi Arabian government directed them to assist the hijackers, and they did not knowingly assist them in their hijacking. So you have to ask about the scope of the employment, and they're going to do that. They say there is sufficient evidence to raise questions as to the true nature of their employment. Were they working for Saudis or not? When viewed as a whole, the total evidence creates a reasonable inference that their employment was more than what their official job title suggests. They had frequent interactions with the hijackers from January to May, and involved important logistical events for the hijackers' settlement into the United States. This is a federal judge writing this. Besides the material assistance Bayoumi himself provided, he also seemed to serve as a connecting point between the hijackers and many other people who had provided assistance to the hijackers at one point or another. For example, Bayoumi knew Thumieri personally and frequently frequented the King Mosque, and they were visiting. All these connections raise questions. Are they employees? Are they just here like doing aviation training or something? No. Additionally, it's undisputed that this one Saudi knew Sadan and Suderi, who worked for the Saudi embassy and took a video of the city with them. And lastly, around the time he helped the hijackers get settled in San Diego, there was a significant increase in his salary, right? So soon as wild, man. So the Saudis too, huh? KSA and Bayoumi failed to provide a plausible explanation as to why this much increase occurred, and KSA accordingly failed to rebut the logical inference that the pay raise was related to assistance for the hijackers. Now, all this evidence, federal judge, taken together shows that Bayoumi had ties to multiple people working for the MOIA and the Saudi government, and cast doubt on whether Saudi truly sent them to simply pursue studies, which is what they tell us. They're just, researchers from China. I just want to come cure cancer for us. By getting himself involved in the hijackers' preparation for a terrorist attack, Bayoumi appears to have done much more than any typical accountant or data processing tech would do. And it appears that bears some connection with his employment by the Kingdom of Saudi Arabia. Judge, as to Thumieri, the other guy, the court also finds it significant that when tracking the hijackers' traveling path, they chose LA as their initial destination. They also revisited LA and didn't want to live there. It makes one wonder, who in Los Angeles did they hope to see, or what did they intend to do there? This naturally puts the spotlight on Johar and Thumieri, the two people based in LA that they interacted with. And further, the families provide ample evidence of their numerous phone calls. It also suggests that they were likely employed by Saudi to assist the hijackers and coordinated with these people to some degree. They also had phone calls with the imam and saying they were communicating with the imam about the hijackers. And so all this evidence, says the judge, taken together, creates a strong inference that it is more likely than not, for the limited purpose of jurisdiction, that these two were not just acting as an imam and an accountant, okay? Their employment with KSA likely had some connection to assisting the hijackers. The inferences are compelling in the absence of an alternative innocent explanation for their conduct, which otherwise leads us to support a conclusion of knowing assistance to the 9/11 terrorists. Under New York law, an employer may be vicariously liable for their employees' acts. And so now the question is, what are these people? Are they employees? At the time, place, and circumstances, they were highly connected to the employment of all of this. Saudi sent them to San Diego, funded him. By the time he started, he's traveling all over the place. Multiple mosques, he was employed. In actual practice, they had a history of employer-employee relationships with these two dudes. Okay, it was very much boss-employee. Turning to whether this tortious act is commonly done, the record is unclear as to where the money came from that was spent on behalf of the hijackers. Yeah, where did it come from? These individuals were Moya propagators, and they shared some similarities with the hijackers. And the last and most important factor clearly favors the plaintiffs as well. And so they have provided evidence that creates the overall impression that these two were not just accountants and imams. Their employment had some connection with assisting the hijackers. They were in direct communication with Saudis during their relevant activities, and they assisted and provided support to the hijackers. They acted within the scope of their employment as employees of Saudi Arabia. Because the factors applicable for the doctrine of vicarious liability, we have met the jurisdictional exceptions. And this is only about jurisdiction, okay? So we're going to allow this to proceed, but it's worth ultimately noting when the question of scope of employment comes in, the fact finder may reach different conclusions. We're just asking about jurisdiction. Now, although there is less evidence about their actions, it's about jurisdiction, and so we can just march forward there. Now, the court bases its above finding records on the evidence that we have reviewed and is uninfluenced by the parties' more generic and conclusory allegations that lack evidentiary support. For example, they say that they hosted a welcome party for the hijackers, but nothing in the video says that the hijackers were the focus of the party. It just looks like a party. Based on the short, infrequent appearances and the very brief introduction, it's overly conclusory. And so we're not, the judge, I am being fair and looking at it, here's why you're not 100%. But despite not giving weight to the overly conclusory statements, the court still finds that they offered sufficient evidence to substantiate their material allegations that these were Saudi employees. And ultimately, Saudi Arabia did not satisfy its burden. The court finds that their assertion is lacking. They say, well, no one in the Saudi government actually directed these people. They said, well, that's lacking in force. There's multiple pieces of circumstantial evidence that shows that they were coordinating with the Saudi government and providing assistance to the hijackers. For example, there were several phone calls made between Bayoumi and Thumeri, between these people and others, right? Everybody's calling each other. Saudi Arabia argues those calls were related to education, requests for religious materials, and other things. It is also unpersuasive, given the frequency and the timing of the calls, how the calls between the individuals were made. And it's their burden to show it's not related to the hijackers when it looks like it's related to the hijackers. And lastly, the court finds that their argument is unconvincing, saying, well, they acted on their own. It's not anything that we wanted them to do. And so we're immunized because they were acting outside of the scope of their employment. But the plaintiffs have managed to provide reasonable evidence that these guys were assisting the hijackers from the Saudis, and they did not proffer sufficient evidence to the contrary. And although KSA attempts to offer seemingly innocent explanations, they're either self-contradictory or not strong enough to overcome the claims. Now, they're allowed to prove their case at trial. This is just about jurisdiction. Overall, the parties dispute a significant portion of the facts. They're free to their own interpretations. But there is no dispute as to the dates and locations of the meetings with the hijackers in LA or San Diego. The parties quarrel over whether these were pre-planned or by chance. It's also undisputed that one of these people, Bayoumi, offered various forms of assistance with the hijackers' apartment, brought them to Parkwood, where he lived, helped them fill out applications, signed a lease as a guarantor. However, the parties disagree as to the motive. It's undisputed that a notepad page had an airplane drawing, but what's the meaning behind it? Some of the disputed facts cannot be resolved right now, so it has to go forward in trial. Nonetheless, the entire body of undisputed facts and the court's preliminary assessment means we've got jurisdiction here. The court's examination is limited to actual and direct circumstantial reasonable inferences, and the Saudis did not carry their burden to say that they're immune and excluded from jurisdiction here. And so therefore, their motion to dismiss for lack of jurisdiction is denied. The clerk of the court directed to terminate the motion. Thank you to George B. Daniels for that decision. And that's interesting language from a federal judge saying that there's pretty strong evidence that the Saudis helped fund the hijackers. And that's something that I think a lot of people were concerned about and there were conversations about, but now it has come to full fruition. And what we just did, what we're doing right now, is reopening the entire set of tabs so we can see if we can get some of this audio working again and do a test on this one. Once this puppy loads up, if it loads up, weird things happening on the computer right now. Strange behavior. All right, not working. All right, tried it. All right, we got one more segment to get to today, and then we'll wrap it up. Going to be a short segment because we're not playing any videos today. But here we go. Kamala Harris stripped of her Secret Service protection. Why? She was never entitled to it. This came to her courtesy of a secret Joe Biden auto pen memo, maybe, that extended her Secret Service protection beyond the regular 6 months that all vice presidents get. So just like Joe Biden was funneling out cash to everybody, Stacey Abrams and the rest of them, oh yeah, climate change. Now, this additional handout is being rescinded. Here's what CNN says. Trump cancels Kamala's Secret Service detail that was extended by undisclosed Biden order. Says Trump revoked Kamala Harris's Secret Service protection according to a copy of a letter that they got. Says former presidents receive Secret Service protection for life. Harris, as a former vice president, received 6 months of protection after leaving office according to federal law. That's expired. Kamala, that period ended on July 21. However, her protection had been extended for an additional year via a directive not made public until now, signed by then President Joe Biden shortly before leaving office, according to multiple people familiar with this undisclosed arrangement. What a scam. That is the order Trump, nobody was going to know. That is the order that Trump canceled in his letter. It's a memo for the Secretary of Homeland Security from them. You are hereby authorized, the letter says, to discontinue any security-related procedures previously authorized by the executive memo, beyond those required by laws for the following individual effective September 1. Former Vice President Kamala D. Harris. That's the full letter. The order to remove Harris's detail came from the White House. One official with the Secret Service said, the decision was not part of a security review or a new threat assessment, the source said. No, it's about, following the rules. Leadership within the agency did not flag any security concerns, who noted that her detail would range from a dozen to a few dozen agents depending on her schedule. She can hire her own security. Trump's ending of the protection is timed perfectly, right as she's about to embark on a high-profile tour of her new terrible book called 107 Days, The Worst Experience of Our Lives. Her new memoir on her short presidential campaign is going to be released in September. She's grateful to the Secret Service, is what her team said. And presidents and presidential candidates face security threats. Biden's spokesman declined to comment. What led to this order signing? But what will now disappear, maybe Kamala did it. Maybe she just went back in the auto pen and she's like, I love this security. This is great. Just typed one out for herself. With her detailed cancel, Harris aides are worried they will lose the same access to threat warnings. No one cares about Kamala. No one wants to take her out, okay? The people familiar, and I don't want them to either, says the people familiar with her security operation said her home in the middle of Los Angeles will also stop being protected by federal agents. Yeah. The cost of mounting this would be millions of dollars annually. Harris's husband, Doug, lost his own personal detail under the standard provisions, and the California Democratic governor expressed outrage. He said the safety of our public officials should never be subject to erratic, vindictive political impulses. It wasn't. Joe Biden broke the law. He extended it. The law's 6 months. She got her 6 months. She doesn't need it anyways. So we're saving money now. You're not entitled to endless protection courtesy of the federal government. And let's see if this plays. No, it doesn't. The internet hates me. All right, so we will leave it there, my friends. And of course, see if we can get the sound working again. But Kamala Harris has been rescinded. Her Secret Service protection is now gone. We'll keep our eye on that. All right, let's see who's here and joining us on the day. What a beautiful Friday stream it has been. And we're very glad to have you here. Thank you for sending in some donos and some love on this beautiful and an amazing Friday. We had a couple great comments that came in right now from Ravicus. What's up? Hey, says, not sure if you talked about it yet, but Judicial Watch says, yeah, Ashley Babbitt is going to get a funeral, an Air Force funeral with honors, which is awesome. And we didn't do a segment on that, but yeah, I did see that. So, man, that's great news. Thank you, Ravicus, for flagging it. Hey, what's up? Simone Garcia in the house. Welcome aboard, Simone Garcia. Very nice to have you here. Appreciate you joining us. Hopefully we see you in the after party. Mike, who's Cheese Harry? Who Cheese Harry? Something. Oh, gosh. Anthony Williams. Welcome. Ken Loves Murica. Ellen Brunetto. We got Kopak, Warcry, Kevin Kessler, Jonathan Haynes, SS Go Hard Gaming, M. Rivers, and Ron Little. Gifted membos, courtesy of Mike Who Cheese. Oh, gosh. Oh, my God. Yeah. Dang. All right. Yes. Tarpon Springs Nazis above the law. Love the show, Rob. Come on, hit that like button. Hey, what's up? Lisa Osler. Watch Codex 9/11 mind-boggling. Watch Codex 9/11. Mind-boggling. What about Monday? A Labor Day holiday, says Dan. What about Monday? Well, nothing's changing for us. We're going to be here, baby. Bonnie says, in April 2025, Fannie Mae terminated over 100 employees for fraudulent and unethical conduct, including some involving mortgage fraud, demonstrating that such behavior is taken seriously within the government-sponsored enterprises. Well, that's a great comment there, Bonnie. Yeah, they could just submit a list of names. Yeah, it's unethical conduct, mortgage fraud. You can't have you here in a place of financial stewardship when you are a bad financial steward. NY, Cook was in banking and knew how to abuse it. These were not innocent mistakes, right? She rounded up all these properties fraudulently, fraudulent mortgages, and then got appointed. So she was like offloading some capital, I think, and making those purchases before she was going to be scrutinized. Ravicus, this is a must read if you want to learn about the Federal Reserve. The Creature from Jekyll Island, What is Money? Yeah, and it's a very short book, very short read, and important. And you can listen to the audiobook. That looks like one of those on YouTube. A lot of people have read it and shared it and talked about it. This one came in from Bucky's is Rome. Thank you, Bucky's. Says, it sounds like both sides and Cobb will agree to convert the preliminary injunction motion that expedites both the process and appeal. For now, it does not appear that Judge Cobb will grant any hold on Cook's firing as this plays out over the next few weeks. That's some analysis courtesy of Julie Kelly. Thank you, Bucky's, for sharing that one. NY, what's up? Plagiarism. I mean, they didn't have problems when Biden did it. Few people to this day know Biden dropped out of the 92 presidential race due to plagiarism. I know, they just shoved him back in there too and stole it from us. Hey, DeTreville. What's up, DeTreville? Great to have you here as a member. We'll see you in the after party. And this old guy says, hey, Rob, why are Federal Reserve governors appointed for 14 years? That's a really long term for a public servant. Yeah, because they want to have power and control for as long as possible. So 14 years just made sense. I don't even know where that number comes from. But Yeah, and there's basically no oversight, no auditing. They do whatever they want. It's ridiculous. Chubby, what's up, says, every time you mention Judge Ali, fabulous he, Ali Ababa. Song from Aladdin in my head again. Miserably. What's up? Chubby Stubby. Dang, says Aladdin. This is a great show. Hey, rub some dirt on it. FYI, for any watchers with a telescope not permanently parked in the hobby closet. I have this on my calendar because I am Blood Moon. Get ready for a red moon on September 7th as a total lunar eclipse lasts 1 hour and 22 minutes. And we'll see that one from the Americas, right? There's another one. I have it on the calendar. I put it on the calendar. We're going to be out there on Blood Moon Day, probably. Rubos. Hey, what's up? The Rubos in the house. Hey, from the bottom of our hearts. Thank you, Rob. Love you guys, Rubos. You guys rock. Thank you for that. Lauren Wimberly. Her security detail probably asked for it to be canceled. Her security detail probably... Oh, because they don't want to have to serve her anymore. All her Secret Service agents are like, whew, we're off that. It was a long one. Thank you for that, Lauren Wimberly. And Uncle Bozy says Labor Day is a commie holiday anyway. I know I've never really appreciated it. Like, I never really get it. It was like the Labor Party, right? Like kind of the socialists. Like I've always... Although I'm, I think, a little bit odd on this one. Like, when I was running the law firm, man, it's like, I hated all the federal holidays. I'm like, how many do we have to give you? How many? And then Lily would come in and say, well, here's what the rules are. I'm like, oh, my gosh. And then it'd always come up. And they'd be like, well, do we get MLK Day off? I'm like, are you going to go celebrate MLK? Are you going to go march or something? What are you going to go do? Anyways, they didn't like that a whole lot, but you know, we like to get stuff done, baby. Spuds, hey, like that smash button, like it hard, like it extra hard today. Thank you for doing that. And sorry about the sound today, my friends, makes me frustrated, but we will see who's joining us over on X, and we're going over to the after party on the day. We got a couple comments on X. Why do puppies load? What do they load? It's a great question. I don't know. B. Torn, good news. Air Force grants funeral honors to Ashley Babbitt. Man, that is just great. Well, you know, they gave Brian Sicknick like that state funeral, even though he died of natural causes. Ashley Babbitt got shot in the chest by a federal agent who was incompetent, who left his gun in a toilet, and then got a private residence hoisted up in the Biden administration as a hero for shooting and killing a woman who was in a building. All right, so good stuff, my friends. Thanks for being here. Thanks for joining us on the early stream. I hope your Friday is just amazing for the remainder. Your boys got some wedding errands to run, so Alexis and I will be out doing those things. That's what we're doing this afternoon. And we'll, of course, stick around for the members only after party. So we'll debrief, we'll say see what else you have to say about the day and the stories, and hang out for a bit. YouTube members, hang tight. We'll drop a link in the chat, and then we'll see you over there. Locals, friends, you don't have to do anything. You just stay on the same screen. YouTube, join us on the new feed. And my friends, we hope to see you there. But before we wrap it up on the day and say our goodbyes on this lovely Friday, Dan says, Biden left the 1988 presidential election, not 1992, related to plagiarism and attribution. Thanks for the correction there, Dan Sundin in the house. Before we wrap it up, my friends, want to thank our amazing mods and meme smiths, K Bean and Carrie B in the house. Thank you for clipping. Donut Mind Me, John McGarvey, Janek, Neuro D, Dog Digger, Just Rhonda, Elliott, and Geegum Geegum, all modding the fort down for us, keeping things nice and beautiful around here, and we appreciate it. But my friends, it has been a great week. Thank you for joining us, covering all the stories that have been popping, and there have been a lot of them popping. It's been a lot of fun and a privilege, and I want to wish you the best weekend you can possibly imagine. I hope that you're out there doing something fun, spending time with family, friends, the people that we love, getting some vitamin D, some fresh air, some exercise, sleeping in, having a scoop of ice cream, and enjoying yourself, because we need to rejuvenate our souls and our spirits and restore our bodies so that we can come back on Monday to get into it again. Because in order to do that appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends, and an amazing Friday. We'll see you right back here on Monday. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see